Hi, and welcome to Disputed, the Norton Fulbright podcast. We are your hosts, Andrew McComb from Toronto and Ailsa Bloomer from Calgary. In this episode, we're talking about cryptocurrency disputes, and in particular, we're focused on questions of jurisdiction. One of the interesting things about blockchain technology is how easily it flows over borders, and how a decentralized ledger can be supported by computers in many different jurisdictions at the same time. When that ledger becomes the focus of litigation, a central question may be where that litigation is properly brought, and what law governs the relationships and legal liabilities in play. Crypto litigation in Canada is in its relative infancy, and so to seek a perspective from further ahead on the curve, we spoke to Bob Schwinger. Bob is a commercial litigator in our New York office. Bob focuses his practice on complex, high-stakes business disputes and has successfully represented both domestic and international clients in matters involving media and technology, private civil antitrust, financial fraud, securities, and intellectual property, including copyright and trademark litigation, trade secrets, and theft of ideas. He also advises clients on risk issues surrounding financial technology, and he writes a column, the Blockchain Law column for the New York Law Journal. As a result, Bob follows developments in crypto litigation in the United States and in other jurisdictions very closely, and so we thought he was the perfect resource to speak to for this conversation. We hope you enjoy it.
Bob, welcome to the podcast. Thank you very much for joining us.
Thank you. Good to be here.
Now, as we've noticed, you've taken a great interest in blockchain-related litigation, and you write a regular column in the New York Law Journal on issues related to blockchain and cryptocurrency litigation. And we are going to go into the specifics in a moment, but we just want to get a handle on the technical stuff here first. So to start, can you give us high-level an explanation of what blockchain is and how it works?
Sure. Blockchain is really just another kind of database technology, and it's often referred to as what's called a distributed ledger, as opposed to something which is more centralized. Typically, when we think of someone maintaining a ledger of business records, there's one person who's the master of the ledger. All information has to pass through that person. They record everything in the ledger, and it's a centralization of all the data. Blockchain is designed to be a system where instead of having one central copy of the ledger that one person maintains, there are many, many copies of the ledger out there that many people have access to. And the idea is that through various cryptographic techniques, you can keep all these ledgers in sync, and so that they're as reliable as the old centralized ledger. And since they all have to be in sync, there is less concern that one person could disrupt them because they all have to match all the time. And that enables you to perhaps solve certain problems or perform certain functions that maybe are not so as easily suited to existing centralized database technologies.
So that distributed nature across a lot of systems with a lot of people looking at it is what I guess reinforces the strength and security of it. I mean, for someone listening who's heard the term blockchain, Bob, can you help us visualize where that term comes from as you sort of apply it to that framework you've described?
Sure. Part of the way the database is set up, the ledger is set up, is each item of information is sort of referred to as a block. And so if you imagine, say, a series of transactions, A sells to B, B sells to C, C sells to D, each one is a block on the chain. And you can, for example, if you have a blockchain that represents ownership of an asset, for example, like, the way a clerk, keeps a register of who owns a piece of land, you can track the passage of the ownership through the blockchain as A sells to B and B sells to C and so on through all the various steps in there. And every time a block is added, there are these very complex processes which are followed to make sure that it's legitimate and that all the other copies of the ledger are being updated at the same time and in the same way.
Just on that point, on these complex processes that are followed to make sure that whatever's recorded is legitimate, the transaction is legitimate, I just wonder where the protocol or rules come from to process and verify these kind of transactions. Is it all in a trust-based system amongst a global network of computers where people don't actually know each other? I mean, what's the protocol around the process?
Well, one of the protocols certainly is that it is sort of anonymous, or at least pseudonymous. No one really knows who anyone else is. They're all working within the system to do it. And this gets into a level of technicality, which is perhaps beyond the scope of what we want to get into here. But they are using incredible amounts of computing power to perform very, very high level mathematical problems, often in certain versions of the database, which helps ensure each node on the database is proceeding correctly. I will admit that the cryptography of that sort of is the precise details that elude me, but I'm not a computer scientist. But it appears to be, sort of pretty reliable. Although, new developments in computing power are always possible, and if there was a tremendous breakthrough, all of a sudden computers were 10,000 times more powerful than they were today, those systems perhaps might need to be reevaluated as to whether they are still impregnable to hacking and tricking and so on. But right now, people feel that they can keep everything in sync and keep everything legitimate.
So we talked at the outset about blockchain and cryptocurrency as terms, and I think most people out there are going to appreciate that Bitcoin is probably the best known example of a cryptocurrency. But of course, cryptocurrencies aren't the only sorts of things being recorded on the blockchain. And you started, Bob, by saying, I think quite helpfully, that this is just a different way of recording information. So can you give us a sense of what some of the applications are for the technology as we currently understand them beyond the Bitcoin example?
Sure. Basically a lot of times what the individual blocks on the chain, which are also sometimes referred to as a token, because essentially you pass the token from one block to the next along the chain. They are an electronic representation of an asset of some kind, or the rights to the ownership of an asset. And it could be an asset which is intended to be a function as a currency, or it could be an asset that's intended to function as something else. Among the ones that are intended to function as currencies, like cryptocurrencies and like Bitcoin, you have sort of, I guess, two main groups. The ones that people are most familiar with, like Bitcoin, the assets are volatile. Their value is not necessarily fixed. They can go up or down. And that's why always people say, ask about what is Bitcoin worth today. There are another group of essentially currency-like assets, which are referred to as stable coins, and somewhat like a money market mutual fund. Their value is intended to be stable at all times. And that can actually be, very useful in payment situations, because if you have a coin or a cryptocurrency which is going to go up or go down dramatically in value tomorrow, the holder may not want to spend it, or the seller who's selling something may not want to take it if its value is going to, depending on which way its value is going to go. Whereas a stable coin, much like, say, a dollar bill, it'll be $1 today, it'll be $1 tomorrow. So that may have a more application in situations where people are not looking to sort of speculate on the value of the assets going up or down. Sometimes people have used tokens to essentially function kind of like securities, when people are raising money to develop a project or develop a company or something along those lines. And sometimes not always clear if the token is if it's supposed to be a currency or is it a security, and sometimes the line legally may not be clear. Sometimes you have things called utility tokens, which are kind of like, if you go into a casino and you buy chips. I can't take a casino chip out in the real world and spend it, but in the world of the casino, it has a value and I can use it, to play games. And so that's another type of application that you can use it for. And also, conceivably, you could use it for things which are really just fairly mundane, such as, for example, if you're maintaining a registry of who owns title to a property or who owns a particular share of stock, the token could be nothing more than simply the ownership rights to a plot of land or 1,000 shares of XYZ corporation.
And it doesn't necessarily have to be only one category, right? I take it a token could be something akin to a security and then also function as that utility token within a company's ecosystem to be used for whatever it is that company is developing itself to be.
In general, that's correct. But that's one of the issues which has become a very complicated issue legally right now, because sometimes these things have characteristics of a security, sometimes they have characteristics of a currency, sometimes they have characteristics of a utility token. And it's not entirely clear right now whether they only have to have one characteristic, or could they be both at the same time, which then raises complicated questions of, if there are multiple things, do multiple government agencies get to regulate them? Do multiple sets of rules apply to them? And often people fiercely debate even which of them they are. And there's obviously a lot of litigation, for example, in the US, about whether things which are marketed as currencies are really, in effect, securities.
And so just picking up on that point then, can you talk a bit generally about the new legal issues that are being raised by the emergence of blockchain and the products that you just mentioned?
One of the, I guess, certainly the biggest issue of the last 2 years has been the issue of whether these things are securities. In the U.S., there's a legal test that comes from nearly 80 years ago at this point. You basically look at, say, if you are asking a group of people to give you money and say, I'm going to take all your money, I'm going to pool it together, I'm going to do something wonderful with it, and you all will earn a profit. That makes you a security. And it seems like for many of the cryptocurrencies that have been issued, in one way or another, they are kind of telling that story. You're telling people is that, you give me my money and I'll make you a profit. And that usually is a hallmark that gets you into the camp of being a security. This is a very still developing area, but a lot of the regulators believe, and a lot of judges who've heard cases believe, that most of the time these facts make things out to be a security. This is not a totally resolved issue. Even if it's not a security, it's still, like anything else that has value, it's likely considered to be a commodity under the federal commodity laws in the US. Just the same way you could speculate on the value of pork bellies or wheat or oil, you could speculate on the value of what Bitcoin will be. Will it go up or down? Are you going to go long or are you going to go short? So even if you're not a security, you could be a commodity. And some people have suggested there are times when you could be both. And these are issues that the legal system in the US is grappling with constantly right now.
And ours too, Bob. I mean, it's interesting. We've dealt with cases, and there's been a number of cases as well in Canada at the regulatory level, dealing with the same questions, and in many cases following the same analysis that the SEC, for example, is going to apply in considering whether an initial coin offering on the blockchain is something that is in fact a security and therefore, subject to regulatory requirements. But I think that's a good jumping off point to talk about sort of a big picture question. And one of the reasons, the primary reason really we wanted you on the podcast, is being a US based litigator focused on this area and following developments. So much of what happens in the Canadian litigation landscape, with all due respect to everything happening in our provinces, does tend to follow a little bit what's happening in a larger set of jurisdictions like we have in the US. So you're maybe a little bit ahead of the curve on us in seeing what's happening. So what is it, in your view, about blockchain that raises new legal issues when it comes to something like, commercial disputes?
Well, there are a few things. One is that, first of all, we have essentially created kind of a new class of asset, which never really existed before, a digital asset. And we went to law school, 40 years ago, the world was sort of divided into personal property and real property and, categories like that. And now there's a digital asset that we haven't really quite written the rules for. And so a lot of things are being done by analogy and by extension. And if people feel that the analogies and the extensions aren't working well, perhaps they will write new laws or write different regulations for this particular situation. But right now we're in the very indeterminate state. It's like being a railroad lawyer in the year 1830. There's most things haven't yet been resolved. And so that's it. So as a lawyer, it's an interesting stage. As a client, unfortunately, clients want certainty. But unfortunately, the legal system is really not quite at that point yet. Another factor which comes in here is because it's so electronic, it's very easy for it to be international. When you buy and sell a piece of real estate, if it's in Ontario, Canada, or in New York City, you know where you are, and you're not going to wind up in California or someplace else. But with electronic tokens, the purchasers and the sellers and everyone else involved, they could be anywhere on the planet, and that can lead to a lot of complex jurisdictional and other procedural issues in the practical world of litigation. Because as all lawyers know, it's great to have a right in theory, but unless you can walk into a court someplace and get it enforced through a judgment that literally could involve someone, going there and seizing assets from the wrongdoer and giving them to you, your rights, in a practical sense, really aren't worth all that much.
And it's a bit cyclical too, right? Because, what you described earlier about the regulatory uncertainty about whether a token offering is a security or not, that regulatory uncertainty in places like Canada and the United States, I think in some cases leads issuers to look
to organizations offshore to help them run their coin offerings from a different jurisdiction, from a different domicile, so as to give them some regulatory or jurisdictional cover down the road when people ask questions about, well, what exactly are you trying to do? And so that tends to sort of feed this international nature of these relationships, because they're not just starting and getting sold in one place. And that's probably another good jumping off point with you, Bob, because we know you've written a couple of pieces, among many others, on, first of all, on the question of personal jurisdiction in the US law. So maybe can you take us through that issue of personal jurisdiction and how that's been developing in US law as you've seen it?
Sure. As anyone knows, if you speak with lawyers from around the world, they all know that the United States is very aggressive in asserting jurisdiction any way it can, at least its courts are, and that the often very, very small contacts with the United States will be used as the hook to say it's appropriate for this lawsuit to be heard in the U.S. courts, even though it involves perhaps many foreign parties and things which took place in other countries, if there is enough of a linkage to the United States. And the courts, and aided by the lawyers for the parties who obviously who are looking for United States jurisdiction, will often search very aggressively for those hooks in order to keep the case in the United States, because we have a theory that a plaintiff is usually entitled to have the case heard, where they decided to bring it, if it's an appropriate jurisdiction. We don't necessarily require the best jurisdiction; it just has to be in the pool of places that's one of the acceptable choices. And so you get cases which look at these complex international fact patterns, and they see if there's a basis there for conducting U.S. personal jurisdiction over the parties.
So one of the first of those cases that you've written about, that's the Alibaba case, right?
Right. Which, strangely enough, really isn't really a crypto case in and of itself. It was a trademark dispute, but it involved someone who was using the Alibaba name to issue a coin, and they're being sued for trademark infringement, and they were attempted to be sued in the United States and in New York, and they had a battle over whether there was anything linking the issuance of this coin to United States such that they could hold jurisdiction over them in the U.S. courts. Often these transactions involving with blockchain and cryptocurrency are involving a string of different countries, and in that case, for example, when they sold the coin, the Alibaba coin in that case, they said, well, our contract says is that the transaction occurs in the place where we make the change in the ledger, and we keep our server in Belarus. Therefore, all the transactions take place in Belarus, even though, people who were engaging in these transactions, some of them were in the United States. And therefore, so we're entirely outside the United States. You can't have jurisdiction over us. And perhaps not surprisingly for a U.S. court, the U.S. court did not agree.
It's interesting, the Alibaba one, because I think both the plaintiff and the defendant the plaintiff was in China and the defendants are Belarus and I think Dubai as well was the other one. And it seemed to me that it was the mere fact that, was it possibly even one or two investors were resident in New York, and that seemed to be sufficient for the court to find personal jurisdiction in New York. And so what specifically did it say when it sided with the plaintiff on finding jurisdiction in the state of New York?
Well, the main thing what the court did is that, and this is not uncommon for courts generally, courts don't like to be hidebound by legal formalisms that don't really comport with reality. And they view that as, clever lawyer games that they're not really going to have a part of. And the court said, look, you can write whatever you want to in your contract, but it strains the normal way of thinking to things, that if someone in New York buys this thing by sitting at his computer in New York and pressing a button in New York, that you haven't engaged in a transaction in New York, and the fact that on the back end somewhere, the computer that's running all this is sitting in Belarus is not really the operative factor. Certainly the plaintiff in New York never thought they were doing business in Belarus. They thought they were doing business in New York. And in this case, perhaps because it was a trademark case, they needed to really show that the mark was being used, and the infringing mark was being used in the United States. And at least in that context, it probably didn't matter whether it was 3 customers or 10,000 customers, because once you're using the mark in the United States, you sort of cross the line that's relevant to that particular case. And there was a bunch of other factors there as well. They said, look, you're doing transactions in dollars. If you're doing a purely foreign, dollars are used around the world, but generally you do transactions in your local currency. If you're doing transactions in dollars, that suggests you're doing transactions with U.S. people. Sometimes you look at what they did to check to see if they knew that they were dealing with U.S. people. I mean, it's one thing if you're dealing with someone completely in another country and then they say, surprise, I happen to have a U.S. passport. But if you're dealing with someone who has a New York mailing address and is operating out of an IP address, which indicates it's from the U.S., you can say that you're on notice that you must be dealing with an American and, not someone from Belarus or Cyprus or, Germany or wherever.
I mean, it's just an interesting idea that you could set up a foreign website to sell these coins and you might not have much oversight as to who's buying them. But if it happens to be somebody that's accessing the site from the US, then you could find yourself kind of unknowingly, unwittingly drawn into litigation in the US. I mean, where's the end to that principle? Is it ever realistic that you could avoid personal jurisdiction if you're offering a global product or something on a global platform?
It can be tricky. I mean, there are ups and downs with having a global product, and one of it is that you can engage in global sales, and you may be establishing jurisdictional contacts, in all sorts of places. So, for example, in the early days, people would have the purchaser check a box on the website that says, "I certify I'm not a United States resident or citizen." But then the courts say, "Well, it's fine that you can check the box," and everybody probably checks the box blindly. But once again, are they paying in dollars? Are they using U.S. financial institutions to process the money? You have to perhaps do a bit more of an inquiry and not just take someone on their word that they say that they're not in the United States. If you really want to claim that I had no idea I was dealing with Americans, then also considering how much of the world economy and the world of cryptocurrency and that Americans are involved in, it's hardly a surprise to find that an American might be engaging in this kind of transaction. So they usually want some sort of pretty robust checking before they will say that, I had no idea I was dealing with an American.
And there's no scope for doing as you would normally do in a commercial transactional context where you'd have a jurisdiction clause and have some certainty as to where a claim would be brought. Like, is that not possible in the smart contract context?
Oh, it is. I mean, you could have, for example, because you could have terms and conditions, just like in a kind of online transaction where you said there's an arbitration clause, that you could say that we all agree that all disputes will be resolved here, and you click a box and check your agreement to that. And some people have suggested that really is ultimately the only way you could have certainty if you're, say, the promoter of this scheme, and you don't want to be facing lawsuits in countries all over the world. You can say, look, we're doing everything. It's going to be arbitration in Switzerland, and that's how we're doing it. And that's a not unreasonable approach. If you chose a crazy jurisdiction that had no link to anyone and it was not sort of a well recognized and respected jurisdiction, you may perhaps get a different reaction. If you chose a court that didn't sort of follow typical Western rule of law type of rules for commercial matters.
And our Canadian listeners who are familiar with class actions law in Canada, their ears may be burning on this topic just because we've had recent decisions thinking about foreign arbitration clauses, attorning to foreign jurisdictions, and the Supreme Court of Canada has looked pretty critically at those. So that's maybe fodder for our next episode with you, Bob. But going back to your first paper, I mean, I think some of the comments that you made are an interesting jumping off point to the second case you referenced, the PlexCorp case, which is a case with a bunch of Canadian links. But again, one where, as Ilsa mentioned, and you were discussing, a company's making efforts to try to show that maybe it's not engaging with U.S. investors, but of course the court still finds that it has jurisdiction.
Right, and that was the case that had some fun facts, because there were some issues of the promoters had traveled to the United States, and they said, oh well, that was just personal travel, but there were indications they had engaged in business meetings or perhaps promotional events while in the United States, or perhaps they were traveling to the United States for promotional purposes.
It sort of looked like a roadshow, like a securities roadshow.
Of a kind, or at least a very limited one, perhaps. And they also focused on the payment method for people who wanted to put in the money. And they said, well, you're using a lot of US-based services like PayPal and Stripe and Square and so on, although it seems to me those probably could be used all over the world. So that's perhaps another example of rather aggressive American approach to jurisdiction. And I believe that the court in that case didn't necessarily rule that there so much that there was jurisdiction, but rather that they couldn't rule that absolutely no jurisdiction. I think they said we need to take a little more jurisdictional discovery to get to the bottom of some of these facts, like the visits for the roadshow and things like that. So all they basically said was it's not a slam dunk that the defendants were going to win, and it's quite possible they're going to lose, but need more information to really sort this out.
Yeah, I mean, just to add a comment there, I think it's interesting the focus in that case, and to an extent in the Alibaba case, on the marketing and promotional activities that occur in the jurisdiction, and to what extent are you targeting consumers and investors in that jurisdiction. I mean, the analysis is obviously useful because it is so applicable in the Canadian context. I mean, when our courts are faced with a jurisdictional challenge, they'll first ask whether the court has jurisdiction simpliciter over the subject matter. And that's based on the test that looks at, is there a real and substantial connection between the case and the jurisdiction? And part of the elements that go into assessing real and substantial connection, they look at, was the defendant carrying on business in the jurisdiction, and where was the contract actually concluded? And that links back to the earlier point we were discussing, where are these contracts actually made? It's not where the transaction is processed on a server that's out in some random part of the world. It's where the consumer, the investor, clicks the button to engage or to buy the product. So I think there are definitely some types of factors in the US courts are weighing that are similar and going to be useful to when these situations arise in Canada.
Yes, I think in the U.S., and I think it sounds somewhat similar to what you were describing as the Canadian rule. The phrase that's often used is whether the defendant purposely avails himself of the benefits and privileges of conducting business in the jurisdiction. If you're in the commercial context, and so, for example, if you go into the jurisdiction to advertise, then you're going to be held perhaps liable to jurisdiction if you're being sued over the very thing you're advertising. It's very specific. You can't generalize it outside the context. But if you are advertising the potential transaction in the U.S., you probably can get sued over the transaction in the U.S. If you visited the U.S. over the transaction, you could well get sued over it in the United States. And you look to things like that. If you were working with a number of other U.S. parties, that could matter. You look at where was the transaction negotiated, where does performance occur, where are payments made, all these things that basically say, look, you were making use of the United States and its institutions and its instrumentalities of interstate and foreign commerce. So you can hardly complain now that the United States is taking an interest in what you did when someone claims that what you did was wrong.
And given the way you've described the sort of international nature of these transactions in the first place, and the difficulty that you'd have in setting up real barriers to prevent those types of links from emerging, it does seem like everybody in this business is engaging in a real risk that they're exposing themselves to personal jurisdiction in the US. And it's a good pivot point to talk about your latest article about extraterritorial application of US law, because I think that's an interesting extension of these same or similar ideas and similar factual findings. So can you take us through sort of high level what we're looking at with that kind of analysis?
Sure. Extraterritoriality is a different legal issue from personal jurisdiction, but a lot of the similar themes emerge in it. Personal jurisdiction is the question of whether it's fair to ask this individual defendant to come to the United States to defend the case. Extraterritoriality is almost more of a question of the political power of the court, which is basically how far does U.S. law extend? I mean, can U.S. law, dictate what a Frenchman and German can do in a transaction that's done in Europe? It would seem somewhat odd. We do have territorial boundaries to countries, and they're supposed to mean something. And so sometimes our laws do project outside our geographic boundaries if there are certain links to the United States. And we have some rules about when we think that's appropriate to be done and when not. And also, there are some rules that basically say, even though that power may theoretically exist, is it always clear that, the Congress really intended to exercise it? And so, for example, sometimes the courts say, if you're telling me that Congress is going to do this unusual thing of reaching beyond our borders, we'd like a really clear signal from Congress that was their intention, and not just, have a sort of a kind of a silent, ambiguous statute that you assert could be applied anywhere on the planet. And that's where the issue of extraterritoriality comes in. It really comes into the power of the court or to the legislature who's passing the statutes, to how far out can they push their laws beyond the geographical boundaries of the country.
So in the blockchain context, that takes us to the Helbiz case.
Right.
Can you take us through Helbiz?
Sure. Helbiz was a sort of a rather typical case in which someone alleges that that the defendant conducted a coin offering, and they claim that the coin offering really was effectively an offering of a security. And they accused the defendant of running what is called a pump and dump scheme, where you get a lot of people excited at the price, you raise a lot of money, and then you disappear with all the assets, and everything crashes. But interestingly, even though it sort of sounded like a typical securities fraud case, the plaintiffs did not plead it as a claim under the U.S. federal securities laws. Instead, they pled state law claims, the U.S. equivalent of provincial law claims, under New York statutory law and New York common law. And they avoided all the federal law, in part probably because they were somewhat worried about the extraterritoriality issue, and they knew that under federal securities laws, they might have a problem with that. And then the question was, what sort of contacts did this whole situation have with the U.S.? Apparently, while the Helbiz company itself was, I guess, nominally, based in Delaware, all the people who were doing things were allegedly based outside of the country. And I believe the plaintiffs were outside the country as well. And so the defendants said that, look, this is an extraterritorial situation. Everyone is outside the United States. The transaction is outside the United States. There's no reason for any kind of U.S. law to apply here. Strangely, the trial court looked at this and said, well, I know they don't call it a federal securities claim, but really effectively it is. And as a federal securities claim, we would say that this is too extraterritorial to be in the U.S. courts, so I'm going to throw out this case. And on appeal, the appeals court said, look, that's the analysis that's used by the federal courts for federal law claims about extraterritoriality, but it doesn't necessarily apply to the laws of a different sovereign entity, New York State, when it is accused of extraterritoriality. And it didn't get into what the analysis was. It said, look, I've got to go back down to the lower court for it to do the analysis. But it noted that there's some authority out there which says that the extraterritoriality analysis by New York State may not be identical to the federal one, and also potentially that it might not be identical depending on whether the New York State law claims are statutory claims or common law claims. So there's a whole bunch of analysis that needed to be done. And in fact, the states are all not uniform on that. Different states have different rules about extraterritoriality. So it's all a very specific analysis as to what it might be. And all the court in that case basically says is, all we know is that, equating it to federal law was not the right thing to do. So go back and, let's have a do-over and do it right this time.
So obviously big questions remain to be answered, but it is a curious result insofar as it suggests that federal laws could be prevented from being applied extraterritorially, but state level laws could potentially apply extraterritoriality. And there's obviously, as you noted, there's diverging case law on whether that's a possibility, at least at this stage.
I think it's, and also common law as well, the potential for state common laws to be applied extraterritorially too, I think is really interesting and important. And just on that point, very briefly on the common law point, I'm just thinking about the nature of the relationship between all the actors that are involved in blockchain and these types of products. And so, for example, whether that's the investors, those that are operating the platform, or between Bitcoin miners themselves, for example, what is the nature of the relationship between those actors, and what common law duties, if any, does it give rise to?
Well, this goes back to my comment earlier that it's like being a railroad lawyer in the year 1830. Because most of these issues really haven't been hashed out yet. Obviously, in a direct contractual relationship, we have the normal rules of contract, but many people are interacting with each other in these scenarios who aren't contractually bound to each other. A is contractually bound to B, and B has relationships with C and D and E. And what happens if A tries to sue C directly? And with certain legal theories, depend on contract, but others don't. So, for example, on a fraud theory, you could sue a lot of people who are participating in the fraud or aiding and abetting the fraud in some way that you never had a contract with. But what duties does one party owe the other one in this situation? We haven't resolved that yet. We have a lot of case law about the relationship of parties on a railroad, and when people are driving automobiles on the same road and so on, and even just conventional vendor purchaser situations or something with the laws of product liability. But we haven't quite resolved these things. What relationships are too far to this point where no, those two people are too far apart. One can't sue the other. we're sorting all that out. I mean, and we know it took time, and it took time, for example, in the common law of torts to get past the rule of direct privity for product liability, where you could only sue the person you bought it from. They said, no, if you're involved in the chain of manufacturing, at least in US law, you could often go back to them because they knew ultimately you were going to buy it. That's why they were making it. They didn't make it to sell. They didn't make the automobile to sell it to the dealer. They made the automobile knowing that the dealer was then going to sell it to you. So it's, you could have a lawsuit directly against the manufacturer. We haven't resolved those issues yet in the world of blockchain.
Outside of the issues that we've identified talking about jurisdiction and extraterritoriality, Bob, is there an issue that you see, having studied this area for some time now, that you think is sort of the most interesting or most perplexing issue that's sort of coming down the pike to get resolved in this space? Is there anything outstanding for you that you're particularly engaged in looking for an answer on from the courts?
I think in terms of civil liability, it's a little bit too early right now to really know. But pretty much the whole gamut of things you would normally see in commercial litigation could expect to arise here. We've seen some things, for example, in the area of antitrust and competition law, where, because as we mentioned, the blockchain ecosystem depends on a lot of people working together in coordinated ways. And when you say people working together in coordinated ways, antitrust lawyers, their ears start to perk up a little bit. There was some case a little while ago where one of the ways that the blockchain keeps things consistent is they use what's called consensus mechanisms. So sometimes basically you sort of vote, for lack of a better term, essentially in a kind of electronic way. But sort of, if 85% of the crowd is going one way, the system says, okay, look, that's the way we're going, because we go with the majority. And people say, well, what happens if people start to collude in some way on this thing to essentially to game the consensus mechanism? Could that be an antitrust violation? That's that's an interesting issue. Once again, depends on your sense of who owes what duties to whom in this context, and it depends on what role do you play in the ecosystem. In that case, there were allegations about the people who are what's called the miners, who sort of mine the cryptocurrency, and they're the ones who validate each transaction and put it on the block. And they were accused of being part of the conspiracy. That may be a bit of a stretch, but maybe someone a little bit closer to the action. Maybe it's more plausible to have them be a part of the conspiracy. And what's going to drive interesting cases is just, as we know, a certain number of things, systems fail. A certain number of systems always fail for whatever reason. There's going to be a flash crash. There's going to be a power outage, and all of a sudden people can't get their transactions. Who was bearing the risk that the power was going out, or that the system couldn't handle over X transactions per minute if it ever got stressed to that point? If a cryptocurrency fails somewhere, some cryptocurrency, and all of a sudden it sparks the crypto equivalent of a bank run, everyone gets panicking, wants to pull all their money out of cryptocurrency all at once. Cryptocurrency A fails, and then people start having essentially bank runs in cryptocurrencies B, C, D, and E. There's nothing to do with cryptocurrency A, other than just sort of they're in the same overall marketplace at the time. Does that give the people who may get injured, as to those cryptocurrencies, rights against the people who cause cryptocurrency A to fail?
It's almost like umbrella purchaser law in the antitrust context. Yeah, and the other thing that goes with this, right, is the commercial reality of litigation is that you need, to some extent, a reasonably deep pocket of interest and investment in sorting out your dispute to take it to court to get to a decision after all those dollars and all those years of time to get there. And that, I would think, becomes more realistic as more institutions are comfortable wading into the space and allowing their own clients to get invested in blockchain through their systems. And we're seeing more and more of that every day.
Yeah, and that's a very good point, because as we mentioned, these things can be electronically all over the world. And you may say, okay, I know who the bad guy is, but the bad guy is sitting across the world in Singapore, or is living off the grid in some place, God knows where. You can't find, you don't even know his name. You just may know his computer, his identifying, electronic pseudonym. So, like I said, theoretically, you could sue that person, but you can't really get effective relief against them. But a bank that's sitting on the corner with brick and mortar assets played some minor supporting role in the transaction, and it would be so much easier just to sue them and come up with a theory of why they are at least, partially responsible, or at least share the liability with the wrongdoer because they were working with him. And that's where the issues will really be pushed to the extreme, because people have no choice. And look, either I drag in the bank or I got nothing. And people typically in the legal system don't just throw up their hands and go home. They will keep going after people until they find someone from which they can get effective relief. And you can't blame them if they've been victimized. But that's what our society has to sort out, is where are we going to draw the lines ultimately in this area.
And Canadian listeners are also, many of whom are going to be familiar with the Quadriga example of the founder of this blockchain-based company allegedly passing away and overseas, and everything sort of disappearing and getting locked up. So that example hits very close to home. Bob, the one thing I'm sure of is if you'll entertain it, we will, I think, have to have you back for a further conversation about developments as you're following them, because this has been super, super useful for us, and I think resourceful for our listeners. So thank you very much for your time and for joining us.
We hope you enjoyed this episode of Disputed. If you'd like to find out more about this topic, or how to contact our guests, please visit nortonrosefulbright.com/disputed. Also, if you have any questions, feedback, or topics that you'd like us to cover in a future episode, please do email us at disputed@nortonrosefulbright.com. And if you would like to hear more, please subscribe to Disputed on Apple Podcasts, Spotify, or wherever you get your podcasts.